Namaste students. I am host Kumar Sharma, Assistant Professor, Faculty of Law and Governance, Jayoti Vidyapeeth Women's University. I welcome all of you in online classes, an initiative by Jayoti Vidyapeeth. In the earlier session, we have discussed about the force, and today we are going to discuss about the criminal force. What is criminal force? We will discuss in today's lecture. So now let's start. Before talking about the criminal force, we need to understand what force is. The term force has been explained in section 349 in the IPC. A person is said to use force to another if he causes motion, change of motion, or cessation of motion to that other, or if he causes to any substance such motion or change of motion, or cessation of motion as bring that substance into contact with any part of that other's body, or with anything which that other is wearing or carrying, or with anything so situated that such contact affects that other's sense of feeling. Provided that the person causing the motion or change of motion or cessation of motion causes that motion, change of motion or cessation of motion in one of the three ways described in IPC. First, by his own bodily power. Secondly, by disposing any substance in such a manner that the motion or change or cessation of motion takes place without any further act on his part or on the part of any other person. And thirdly, by inducing any animal to move, to change its motion or to cease to move. This action merely says what is a force, but did not consider it as an offense. This action says what is a force, but did not consider it as an offense. Hence, it is better understood with the latter section which says what is a criminal force, which is again useful for understanding what is assault. The section explains force with respect not only to a person but substance, things that the other person is in contact with. Two things are essential. First, there must be a motion caused or change in motion or cessation of motion extremely, and second, the above, as I said, must be caused to another person either directly or through things or substance he or she is in contact with. If the motion is caused or change in motion is caused or cessation of motion is caused to the external object or substance or thing which the other person possesses or wears or carries or is in contact does not affect that person, then it is not force. It will not be considered as use of force. The court of law is in a better position to study the facts and circumstances to determine what can be called as use of force and what is not the use of force. Like in the case of Chandrika Sao versus the state of Bihar, AIR 1967, Supreme Court 170. The lower court rejected the argument that is merely snatching that book away from the hands of the official, which he was in the official's position. At that time, was not a use of force. The Supreme Court observed otherwise, saying that the snatching of books was capable of fulfilling the essence of Section 349. The book, which was in possession of the official, was caused to have a motion or change in motion by mere snatching it. This affects a sensation of feeling to the official's hands. Hence, it is considered as use of force by the accused. Now, let's discuss about the criminal force. What is criminal force? The term criminal force has been defined in section 350 and it uses the meaning of word force which is given in section 349. Criminal Force IPC says whoever intentionally uses force to any person without that person's consent in order to committing of any offense or intending by the use of such force to cause or knowing it to be likely that by the use of such force he will cause injury, fear or animals to the person, fear or annoyance to the person to whom the force is used is said to use criminal force to that other. There are some illustrations are also available in Indian Penal Code. Number A. Z is sitting in a boat on a river. A. Unfastens the moorings and thus intentionally causes the boat to drift down the stream. Here, A intentionally causes motion to Z and he does this by disposing substance in such a manner that the motion is produced without any other action on any person's part. A has therefore intentionally used force to Z if he has done so without Z's consent in order to committing of any offense or intending or knowing it to be likely that this use of force will cause injury, fear or annoyance to Z. A has used criminal force to Z. Illustration B. Z is riding in a chariot. A. lashes Z's horse and thereby causes them to quicken their pace. Here A caused change of motion to Z by inducing the animals to change their motion. A has therefore used force to Z. And if A has done this without Z's consent, intending or knowing it to be likely that he may thereby injure, threaten, or annoy Z, A has used criminal force to Z. Illustration C. Z is riding in a palanquin. A intending to rob Z seizes the pole and stops the palanquin. Here A has caused cessation of motion to Z, and he has done this by his own bodily power. A has therefore used force to Z, and as A has acted thus intentionally without Z's consent. In order to the commission of an offense, A has used criminal force to Z. Illustration number D. A intentionally pushes against J on the street. Here A has, by his own bodily power, moved his own person so as to bring it into contact with Z. He has therefore intentionally used force to Z. And if he has done so without Z's consent, intending or knowing it to be likely that he may thereby injure, threaten, or annoy Z, he has used criminal force to Z. Further, illustration E. A throws a stone, intending or knowing it to be likely that the stone will be thus brought into contact with Z or with Z's clothes or with something carried by Z, or that it will strike water and dash up the water against Z's clothes or something carried by Z. Here, if the throwing of the stone produce the effect of causing any substance to come into contact with Z or Z's clothes, A has used force to Z, and if it did so without Z's consent, intending thereby to injure, threaten, or annoy Z, he has used criminal force to Z. Illustration F. A intentionally pulls up a woman's veil. Here intentionally used force to her, and if he does so without her consent, intending or knowing it to be likely that he may thereby injure, threaten, or annoy her, he has used criminal force to her. Z is water. Pour into the bath water which he knows to be boiling. Here, intentionally by his own bodily power causes such a motion in the boiling water as brings that water into contact with Z or with other water so situated that such contact must affect Z's sense of feeling. A has therefore intentionally used force to Z, and if he has done this without Z's consent, intending or knowing it to be likely that he may thereby cause injury, fear, or annoyance to Z, A has used criminal force. And there is a last illustration which is H. A incites a dog to spring upon Z without Z's consent. Here, if A intends to cause injury, fear, or annoyance to Z, he uses criminal force to Z. This action gives us what is criminal force and the illustrations to explain the offense better. These illustrations are a combination of scenarios where there is a motion and motion caused or change in motion or a few cessations of motion caused. Further, These illustrations better explain the causes as provided in section 349, which gives us manner in which force can be used. What is the essentials of criminal force? The essential of force are combined with that of the criminal force and shows what exact need to be satisfied to constitute criminal force. Number one, there must be a use of force. Number two, force should be used intentionally. Number three, force used should be without consent. And number four, the force used should satisfy either of it. A. The use of force must be in pursuance to the commission of an offense. Or B. The use of force must be intending to cause or knowing that it is likely to cause injury, fear, or annoyance to the person to whom the force is used. Thanks for watching. Namaskar.